seriously popular.
Welcome to the Trial Podcast, The Inquiry. I'm Caroline Cheetham.
And I'm Liz Hull.
We'll be back in a second.
Você ama garantir uma vaga na universidade com a sua nota do Enem? Então venha para a AMB Morumbi. Aqui você está sempre conectado com o mercado de trabalho e coloca a mão na massa desde o primeiro dia de aula. Tudo em ambientes inspiradores, com metodologia de ensino inovadora e uma estrutura de ponta. Use agora a sua nota do Enem. Inscreva-se em amb.br. AMB Morumbi. Aqui tudo acontece.
I make it absolutely clear that it's not for me, as chair of this public
The decision to move Letby to day shifts raises serious questions which we will be investigating. Was there a cover-up? If so, why?
I would pray for God to save her. He did. He saved her.
The convictions stand.
But the devil found her.
In August 2023, a neonatal nurse called Lucy Letby was convicted of killing and harming 13 babies in her care. She was sentenced to 14 life terms and declared one of the country's most prolific serial killers. A year later, she was convicted of attempting to kill another baby and given another life sentence.
All this happened in the Countess of Chester Hospital over the course of a year from 2015 to 2016. But what went wrong? Who knew what and when? How was a nurse able to kill and hurt babies on a ward under the noses of her colleagues?
The Thirlwall inquiry is now underway in Liverpool and will attempt to answer these questions and more. We'll be there covering events every day. So, this week the inquiry's been hearing evidence from the final few witnesses. They'll now have a couple of months off, and the barristers are all going to go away and collect their thoughts, and they'll be back in March to present their closing statements to Lady Justice Thirlwall. Obviously, we'll be back to cover those when they happen, but for today, we're going to bring you the evidence of a couple of key people who were asked about what's changed in the 9 years since Lucy Letby committed her crimes and what the NHS can learn from the tragic events at the Countess of Chester Hospital.
Yeah, so one of those witnesses was the hospital's current chief executive, Jane Tomkinson. She told the inquiry that significant changes had been made at the Countess since 2015, from ward to board level. She admitted that in the past, staff working there had not felt respected and the culture had been poor. But she insisted managers were now more visible and approachable and were listening more.
Yeah, we'll also bring you the evidence today from a statistician. Now, he explained that although there was a spike in deaths on the neonatal unit in 2015 and 2016, the hospital was not what he called an outlier. In other words, the death rate was comparable to that at other similar NHS neonatal units at the time.
Yeah, and we've got a fantastic interview with David James Smith. He's a journalist and a former commissioner for the Criminal Cases Review Commission. He picks up on our conversation from last week by explaining in a bit more detail Lucy Letby's ongoing attempts to overturn her convictions. Welcome to episode 20, The Final Witnesses.
Yeah, so this is the last of our podcasts on the inquiry for now, before it takes a pause for a few weeks until March. We'll, of course, be back then, but in this final week of evidence, we've been hearing lots from senior civil servants at the Department of Health, regulators, professional bodies, and hospital leaders who've been talking about the general culture, the management and regulation in the NHS, and what could be done to prevent a tragedy like the one that happened at the Countess from happening again. And Liz, one of the key witnesses this week was the current chief executive of the Countess of Chester. Now, she's a woman called Jane Tomkinson, and she was at pains to point out that a lot has changed at the Trust since 2015 and 2016.
Yes, she told the inquiry that she'd got a great affection for the Countess and its staff because it was actually her local hospital. She said she worked there early on in her career as the finance director and eventually the deputy chief executive before moving elsewhere in the NHS in 2011. But she came back to the trust 11 years later in December 2022. That's just after the start of Lucy Letby's trial, and she became the permanent chief executive in February last year. Now, she was asked a lot of questions about what the hospital has done since Lucy Letby's crimes were uncovered, and she was insistent that much had been improved.
Well, I'm really clear that there are significant changes and improvements in that organisation between the period in question and the current day. We are developing a much better and inclusive culture. We are much more open to listening to our staff and have a much clearer and easier way for people to escalate issues and concerns at any level, at any time. Our processes and systems are much clearer and tighter, and we have spent a lot of time in working with our staff so they understand what their responsibilities are in relation to patient safety concerns, how they would escalate them, and what they can expect in terms of speaking out. So the changes are very, very numerous, but I would hope that today the response to anything like the events of 2015 onwards would be handled completely differently from ward through to board.
She was actually pretty scathing at times about the way the hospital was run back in 2015. She said lip service was paid to the hospital's Speak Out Safely policy by senior managers, and there was also a culture of fear, she said, that meant the paediatricians who tried to blow the whistle on Lucy Letby were ignored and bullied. But she said there was now a clear way for hospital staff to escalate their concerns to senior managers, who, she said, were much more open to listening.
The culture is very much influenced by not just the words, but the style and the action of the leaders. And obviously I wasn't there at the time, but from what I've read, it feels like lip service was paid to speak out safely, that there was a culture of fear, that the board was dominated by the views of a number of individuals. It was not a unitary board, and that people were, well, we know, potentially threatened with punitive action if they didn't toe a particular line. So if culture is a product of those behaviours and relationships, it was a bad one, and people can say, oh yeah, well, we had all of this. But if you have a culture where people feel closed down, that they don't feel safe, that they don't feel senior leadership is approachable and open, then it will not deliver the safety culture that we would want for our patients. And certainly my style is very, very different from that which was the leadership style in 2015.
But she was challenged on this, and she was asked about a staff survey conducted in 2022, which reported that many of them didn't feel valued, respected, or trusted. She admitted the results were deeply shocking, but insisted they were trying to turn around the tanker. She said senior managers previously worked in an office block a quarter of a mile away from the hospital itself, but she tried to make them more visible by moving them back on site, and she insisted a more recent internal survey of staff had been more positive.
And that visibility, but that support and listening culture that the executive are leading from the top with, is making a huge difference to how people feel about their place of work. So I think that's really positive.
Yeah, so she also talked about other practical changes. So you might remember during the trial that Lucy Letby was convicted of trying to kill 2 babies by poisoning them with insulin. And although in 2015 and 2016, the insulin was kept in a locked fridge, the keys to that fridge were passed around the neonatal nurses. There was no log kept of who was accessing the keys and that fridge at any given time. Now, she said there was a clear audit trail of who could access the insulin, and this is because they now use what she called bespoke swipe cards, which are assigned to each individual staff member.
She also told the inquiry that she was really pushing for the neonatal unit to get back its level 2 status so they could start caring for premature babies born under 32 weeks again. She said she'd written to regional leaders in the NHS requesting the reinstatement last April, but it was disappointing and incredibly frustrating that no progress had been made on this 9 months on. Nevertheless, she concluded her evidence by saying she was confident that things were on the up.
For me personally, it was difficult to come in and see some of the issues that were still evident in the Countess of Chester. The impact of the harms and deaths will never leave that hospital, and rightly so. We'll never forget it. But people actually want the ambition, they want to focus on the future, learn from the past, but reshape the future in a different way. And certainly the feedback I've had is that myself and the new executive team are making a significant difference at pace on delivery and culture, and it's very welcomed.
Now, as well as giving her evidence in person this week, some longer, fuller statements from Ms Tomkinson provided to the inquiry were also published on the website. Now, we're probably going to see more and more of these over the coming days as the inquiry comes to a close and they start to publish more of these statements that have been given to them. Now, these statements provide sort of extra information and interesting insights that the witnesses might not have been asked about in person when they gave their evidence. And one example of this was in her statement, which included some new details about Lucy Letby's background, specifically her education that we've never heard before.
Yeah, so the statement revealed essentially Lucy Letby's CV for the first time when she applied for the job as a neonatal nurse at the Countess and was successful in January 2012. It showed that she'd passed 9 GCSEs with B and C grades and also passed 3 A levels with C grades in English literature, psychology and health and social care. She also passed her paediatric nursing degree at Chester University with a 2-2.
Yeah, and another document which was published on the inquiry website, which you might have seen referred to in the news this week, is one that's been compiled by the inquiry's legal team, and that detailed all of the neonatal deaths linked to the Countess in 2015 and 2016. Now, the reason this is significant is because it explains for the first time that 17 babies died in total between 2015 and 2016. 13 of those were at the Countess, and 4 died at more specialist hospitals such as Arrow Park and Liverpool Women's after being transferred out of the Countess for more intensive treatment.
So we know, Caroline, that Lucy Letby was convicted of murdering 7 of those 17 babies, but the document's significant because it revealed that the deaths of 2 of the other 10 are still being investigated by Cheshire Police. And we know that Dr. Dowie Evans, who was the main prosecution expert witness, had suspicions about other deaths, and that at the end of last year, detectives visited Lucy Letby in jail to question her about more baby murders and attacks. But the police have never said how many she was asked about, so this is the first time any number has been discussed officially.
Yeah, and now the number of neonatal deaths at the hospital was also discussed by another witness this week, and that was Sir David Spiegelhalter. Now, he's an emeritus professor of statistics at Cambridge University. Now, he's given evidence at other inquiries, including the one which looked into Harold Shipman, and he's also previously backed calls for the statistics to be analysed more by this inquiry. And we know that the use of stats, specifically that shift chart or the graph which was shown to the jury, which showed Lucy Letby being on duty each time a baby was allegedly killed or harmed, has been one of the main points of focus for those questioning her convictions. But Professor Spiegelhalter wasn't asked questions about the chart or the use of stats in the trial. He did, however, begin his evidence by emphasising the need for rigorous analysis and caution before reaching conclusions on data alone.
The reason why statistics are so important is that numerous studies and personal experience have shown that humans are not very good at judging data. They can miss long-term trends, slowly accumulating changes, which they can miss that. And on the other hand, they can perhaps pay too much attention to sporadic runs of bad outcomes due to unknown factors, and trying to find patterns that may not actually exist. So these are well-known human characteristics, and that's why we need statistical analysis.
He said he'd recently looked at the number of deaths on the hospital's neonatal unit between 2010 and 2016, and he said that up until 2015, the number was surprisingly consistent. He said that according to hospital data, there was 1 death in 2010, 2 in 2013, and 3 in 2011, 2012, and 2014. But we know that the number of deaths then jumped to 8 in 2015, and by July 2016, when Lucy Letby was moved off the unit, there had been another 5. And he said he'd calculated the chance of 8 deaths happening in 2015 to be very low.
The probability of getting 8 or more deaths in 2015, I assess to be around 0.008, just by chance alone, assuming that nothing had actually changed, that the underlying rate had stayed the same. The probability of getting 8 or more is that, which is less than 1%.
Yeah, he said this 8 deaths would be considered sufficient to trigger an investigation at a local level at the hospital, like the internal and external reviews that Dr. Stephen Breary and later the medical director Ian Harvey initiated into the spike in deaths.
The numbers have gone up.
The numbers have gone up.
They're small numbers.
Its numbers have gone up. They're small numbers, but just because numbers have gone up does not mean necessarily that there's a special cause for it. That is
As you've
subject to
explained, that needs
investigation.
investigation.
Needs to be investigated.
Interestingly, he stressed that on a national level, 8 deaths would not be considered extreme enough for the Countess to be considered an outlier.
Yeah, he said when compared to the other 150 neonatal units across the UK, he would expect 1 signal of this magnitude in at least 1 hospital every year. He also gave the example of the neonatal unit at Blackpool Victoria Hospital, which in 2015 also had a very similar neonatal mortality rate to that of the Countess.
This is a surprising event within Countess of Chester, but from a national level, this is not very surprising at all. We would expect this to happen every year, somewhere.
We'll take a quick break there.
Você ama ter mais flexibilidade para estudar? Então, use sua nota do Enem e garanta uma vaga na AMB Morumbi. Aqui, você pode escolher qual modalidade se adapta melhor à sua rotina. Presencial, semipresencial ou ensino à distância. Tudo com metodologia inovadora e prática desde o início do curso. Descubra por que milhares de alunos amam estudar aqui. Use agora a sua nota do Enem e inscreva-se em amb.br. AMB Morumbi. Aqui, tudo acontece.
So that is it from the inquiry for a few weeks. But before we go, we did just want to bring you a bit more on the discussion we were having last week about Lucy Letby's new barrister, Mark MacDonald's attempts to get her appeal against her convictions reopened or heard before the Criminal Cases Review Commission. Now, you might remember in our chat with Tim Owen, KC, last week, we talked about an article by one of our colleagues, David James Smith. Now, he's a respected crime and investigative journalist, but he's also has a fascinating insight because for a time he worked as a commissioner for the CCRC. So he had a role in deciding which cases and potential miscarriages of justice were sent back to the Court of Appeal for another look. And we're really delighted that he found the time to come onto the podcast just to explain a bit more about that and what he thinks about Lucy Letby's case. We are now really, really happy to be joined by David James Smith. Actually, David has a few roles, so I might just let you explain what all those roles are, David. But essentially, as well as being a writer and a journalist, you had a role on the CCRC as well. So just walk us through a little bit about your background, your career, and then what brings you to our podcast today, of course, which we're talking about Lucy Letby.
Sure. So, I mean, I've really been a journalist all my working life. I'd never done anything else. I never went to university, started work on a local paper when I was 18, the Harrow Observer, and gradually found my way forward from there. It took a long time. And other people sometimes say that the work I do is investigative, but to me, it's just applying all the kind of basic skills of, a journalist that I learned on a local paper and have developed since. So I joined the CCRC in 2013. And one of the things that I began to realise as I got older was that I'd never done anything else. And was I fit to do anything else? I've been very lucky. I'd had a really good long relationship with the Sunday Times magazine. I'd written some books, but I'd never done anything else. So I applied to the CCRC. I was very interested in miscarriages of justice. I wrote an awful lot about crime, criminal justice system, and I felt I had something to contribute. So anyway, I was lucky enough to get taken on, and I served a term of office at the CCRC from 2013 to 2018. I was one of the few what they call lay commissioners, so I wasn't legally qualified. So the statute, the Criminal Justice Act 1995, by which the CCRC was founded, set out the proportion of the number of commissioners that should be legally qualified, and those that weren't, they wanted a mixture. And that was what I went into. So some of my colleagues were lawyers and some weren't. And we oversaw, hundreds and hundreds of cases, probably about 1,500 applications every year.
How many people are on that panel, David?
So the CCRC is an organisation run theoretically by the 11 commissioners, and one of them is appointed the chair. And the law requires that 3 commissioners sit together to make a decision on whether to refer a case back to the Court of Appeal. So the case working staff are known as case review managers, and they work in teams, and they do a lot of the investigative work on cases, the reading into cases, and then commissioners are the ones who make the decisions and in some cases oversee the investigations.
And are you allocated cases at random then? So many a year, for example?
So in my time there, I don't know if it's still the same now, that we were attached to teams. And so we would be the commissioners for a particular team of case review managers, and we would just work through those cases. And if there were particularly complex cases, then commissioners would be involved right from the beginning, and it was very arcane, some of the language. You'd be known as a nominated decision maker, so you would make decisions about how to investigate cases, and then you would take we'd take the case to a committee. So then you would be, as the lead commissioner on that case, there will be 2 others there, and almost like it's not obviously the same as being a Court of Appeal judge, but they sit in panels of 3, and we sat as panels of 3 to make the decision on whether or not to refer a case. And if 2 of you felt that the case should be referred, then it would be referred.
And we should just say, shouldn't we, just for the sake of clarity, that these are cases that have been through the criminal justice system, all the way through initial trial, conviction, and then to the Court of Appeal before it gets to your door. That's right, isn't it?
Absolutely right. Yes. So the CCRC came into being out of all the notorious Irish miscarriage cases, the Birmingham 6, the Guildford 4, and many others. And it was felt that there needed to be an independent body that would form a sort of place of last resort to go to when the criminal justice system was seen to have failed. And so that's what the CCRC was intended to do. Every criminal conviction can be appealed, and you really have one appeal, one chance per conviction, and then after that you go to the CCRC. It's free to apply, and you can apply as often as you want to, but really if the CCRC has looked at your case once, then you need to come back with something new so that there's something fresh for the CCRC to look at. Pretty much like if the CCRC is going to refer the case back to the Court of Appeal, then there needs to be something new that the Court of Appeal didn't look at the first time.
So if we're talking about Letby's case, you've written a couple of kind of quite long form articles about what you think about the case and what you think about her chances of getting over this CCRC hurdle. It's quite high, isn't it, the bar for once your case has been rejected by the Court of Appeal, twice as hers has been, the bar's quite high, isn't it? But not insurmountable, I suppose we should say.
Absolutely. So the percentage of cases that succeed at appeal based on the number of applications to the CCRC is just a small percentage each year. About 70%, I think, typically of the cases that the CCRC refers to the court are actually quashed. And the CCRC's test is that there must be a real possibility that if they refer the case, the Court of Appeal will quash it. That test, in fact, is going to be subject to review by an organisation called the Law Commission. They're examining it at the moment, and it's possible that they may recommend a different test in the future. But essentially, I'd be surprised if it made that much difference to the decisions that the CCRC makes. So one of the problems with the test is that it gives the appearance that the Criminal Cases Review Commission is kind of like the lapdog, the poodle, is subservient to the Court of Appeal, that it has to second guess what the Court of Appeal will decide. So that's one way of looking at it. But I always felt that we were making, our own robust decisions, and that we were independent. We were independent of the court, we were independent of the government, and also, of course, the CCRC must be independent of the applicants as well. So it can't become too cosy with the applicants, although it must listen to them and go out of its way to understand the case that they're making.
Your most recent article that I read, David, was in The Independent over Christmas, just before Christmas, actually, around another one of your long reads on this, which was really fascinating because you wrote it off the back of reading the 600-page summing up from the judge in the case. And I suppose I'd let you summarise really what that made you think in terms of any doubts you may have previously harboured about her, whether her convictions are safe or not.
Yeah, so just to set this in context, first of all, obviously I'm talking about my own views here about the case, and this isn't anything to do with me preempting what the CCRC might decide with any future application. I don't think an application's been made yet, but I wouldn't necessarily know whether it had been or not. But when I was at the CCRC, if I had a new case and I wanted to understand it, you would read the summing up, which is the judge's summing up to the jury at the end of a trial of all the evidence that had been heard during the case. And he has an obligation to be fair and impartial, and the barristers for both sides are sitting there ready to pick him up if he makes mistakes or if he's showing too much favoritism one way or the other. So you can be fairly confident that it's a really good way of learning what happened at the trial. And I was able to obtain a copy of the summing up in the Lucy Letby case. Obviously, it was a 10-month trial, and it was a huge, huge document. So you could see that witnesses were being called and recalled and returned to, and they were being cross-examined at great length. And I was struck very robustly by Lucy Letby's then trial barrister, King's Counsel, as he would be now, Ben Myers. And it was the first time that I really understood the weight of the case against her. So what I'd really focused on, just following the reporting, I hadn't been involved during the trial, I hadn't attended the trial, but I was constantly thinking about the lack of direct evidence. And in a case where there is a lack of direct evidence, then that could mean that somebody ends up being wrongly convicted. You have to also take account of the strength of circumstantial evidence. And in this case, obviously, the circumstantial evidence is just, kind of overwhelming. There's a huge amount of it. And you could see that it had been challenged. You could see that a lot of the issues that people were raising on social media and elsewhere that they're continuing to raise now, people talking about the poor sanitation, the sewage issue, the risk of infection, that lots of those issues have been considered and subject to testing and dismissed during the trial. So many of the things that people appear to be concerned about weren't really a factor. And I was also struck by the fact that lots of people had tried to focus on the statistical element of the case. And it just seemed to me, having finished reading the 600 pages, that really statistics weren't that relevant to the case.
What did you kind of understand about Letby's behaviour as well? Because I think a lot of that is, her behaviour, the way she gave evidence. Did you get anything about that from reading the summing up?
Well, that she wouldn't necessarily have been truthful, that she may have been perceived by the jury to be obfuscating. And there were things that she did that were very odd and hard to explain. The taking home of all the handover documents, the hiding them, the weird notes which bear different interpretations. And if I'd sat there, I could imagine myself sitting there wondering whether she was being truthful or not.
Yeah. You make the point there, David, that there was overwhelming, as you put it, circumstantial evidence. And of course, many people in the legal profession and who sat through the trial would say circumstantial evidence is as valid as any other type of evidence, and often that's being considered to be a lesser type of evidence. And again, from your experience, it is the case, isn't it, that circumstantial evidence is weighty?
I mean, absolutely, it is. And it's not at all unusual for people to be convicted on circumstantial evidence. But that doesn't entirely, sitting with my CCRC hat on, that doesn't entirely rule out the dangers that it also can present. So people say that it's the totality of it. You draw it all in, and that's what matters. You know, that if you break it all down into its individual component parts, they may look weak, but when you build them all, put them all together, they can look quite concrete. But obviously, if any of those elements of the case are too weak or ill-founded or mistakenly represented, then that can start to, rock the edifice, as it were, and create problems. So that I'm not ruling that out at all. So, I think what I said in this article that I wrote, having read the summing up, was that I could understand how she came to be convicted. But I can't by any means rule out the possibility that there could be a miscarriage of justice. There's a lot of medical evidence which I don't fully understand that could be called forward. And it seemed to me in their second decision at the Court of Appeal that they were almost allowing for that possibility. They made reference to the fact that they weren't about to revisit the first appeal, and that they were aware that there'd been all this sort of, media conversation about the case and concerns about the medical evidence, but they weren't there to discuss that. And it seemed to me that on one interpretation, they were saying that maybe we will get to do that at some point in the future. So maybe there's some encouragement there for Mark MacDonald, who is Lucy Letby's new counsel.
We chatted last week to Tim Owen, KC, a defence barrister himself, and we were talking to him about the fact that Mark MacDonald made the point in that press conference that he's not going to criticise Ben Myers and that team's strategy. That seems unusual, right? That he won't talk to the original defence team to find out what they did, why they did it, for example, why they didn't call any expert witnesses themselves.
He did say that he hadn't approached them and that he wasn't going to criticise them. But if he's planning to call new evidence at a future Court of Appeal, if he goes to the CCRC with new medical evidence, then the CCRC will know that the Court of Appeal will only accept fresh evidence if there's a good reason, a reasonable explanation why it hasn't been called at the trial. So they will have to go and ask Ben Myers what his strategy was. I mean, it is, to me, the great mystery of the case is why there wasn't any medical evidence called by the defence. One can speculate about it, but we have no idea. But Mark MacDonald must know that he can't advance his case without addressing that issue. It's fundamental.
All right, so he will have to speak to Ben Myers and that whole team to find out what went on in their strategy and what they were doing, particularly with regard to the defence expert witnesses, before the Court of Appeal will even entertain it.
Because it follows, doesn't it? He has to know what those original defence experts said to know what's new.
Yes, and also the Court of Appeal will want to know, well, why wasn't this evidence, if this evidence was available at the time of the trial, why wasn't it called then? And why wasn't any evidence called? So, I mean, the CCRC can go and seek that information if MacDonald doesn't present it to them, but everyone will know that it's absolutely an integral part of any future Court of Appeal application to accept fresh evidence.
And if she decides that was a mistake, that Ben Myers made a mistake when he advised her not to call any defence expert witnesses, can Mark MacDonald present new reports, or what would the Court of Appeal think about that? Can they reopen the case on the basis of a tactical error on her defence team, I suppose is what I'm asking.
Yes, I mean, it's such a huge thing. He won't have done it lightly. He will have done it for a reason. In all ordinary circumstances, the reason why people don't call evidence is because they can't find somebody to say what they want. So that's, one position. Whether that's what happened here, I don't know. But I think that the bottom line would be that if there was some really compelling evidence that ought to have been heard at the trial and wasn't, then I would imagine the Court of Appeal couldn't refuse to hear that. They would have to hear it, and the CCRC will understand that as well. So really, although it would be very important, and the Court of Appeal will have to know why it was that the evidence wasn't called at the original trial, and Ben Myers will have to give some explanation for that. if there is compelling new evidence, then the Court of Appeal will hear it and the CCRC will know that.
It's fascinating, isn't it? I would love to have known about those kind of discussions behind the scenes. And let's make no bones about it, she was very, very involved in those discussions, because I found this quite unusual. I mean, I sat there most days, and pretty much at the end of every day, the judge said, Mr. Myers, do you want 10 minutes, 15 minutes with your client before she goes back to prison? And pretty much every single day, the answer was yes. And he went to the cells and discussed that day's events in the trial. So she was obviously very much involved in these decisions and how the case was progressing. But yeah, I mean, it's like you said, only Ben Myers and his juniors and Lucy Letby will actually know the reasons for that decision not to call those defence experts, which has arguably led to a lot of this chatter afterwards about the case, because there's a lot of things we don't understand about that decision.
I must admit, I was quite astonished when Mark MacDonald said at the press conference that he hadn't asked them why. So, in other words, either she's way privileged and he hasn't acted on it, or whatever the reason was. But anyway, I think, it's such a fundamental point that it's very, very surprising that he, wouldn't have gone there straight away to find out what the explanation was. And that's not about criticising them necessarily. It's just about understanding what the decisions at trial were and why they were taken.
Well, that's what I thought was unusual, actually, that it's not about criticising her defence team, is it? It's about, this is her new defence team now. They've got to now find the new evidence, because that's what the Court of Appeal requires. It's what the CCRC would require. So it's not about a sort of criticism of anybody else. It's about a new defence strategy. And surely you can't come up with a new defence strategy without knowing what the old defence strategy was in the first place. And it feels like that's the brick wall he can't get beyond right now if he's not going to talk to Ben Myers.
And actually, you could argue that Ben Myers did a reasonable job because she wasn't convicted of everything.
And just reading the summing up, you could see how much challenge he'd made to the evidence. And I noted that the judge on more than one occasion said that what Mr. Myers said in court wasn't evidence in itself. But you could see that he was working really hard to try and countermand some of the expert evidence that was being given, and raising lots of questions and raising doubts and raising concerns. So even though he didn't have his own experts to call upon, he was doing a lot of work in cross-examination to try and undermine the evidence.
And actually, not for any reason to plug our own podcast at all at this point, but I would actually really urge people to go and have a listen to those episodes where we really focus on Ben Myers and his challenge to, particularly to Dowie Evans, but his challenge across the evidence. He was really ferocious at times and forensic.
Well, lots of his exchanges with Dowie Evans especially were very spiky. They went toe-to-toe a lot.
Yes, and of course he's a hugely, hugely experienced criminal barrister. I mean, he's a KC, and this is one of the biggest criminal trials in recent history, in all history probably. And he wasn't chosen lightly for the task of defending Lucy Letby. And it's hard to believe he made a mistake, quote unquote, in not calling expert evidence. And we're all fascinated to know exactly what happened and what went on and why there wasn't any called.
It's so interesting hearing your take on it, particularly in light of reading the judges summing up, and we'll see what happens. You mentioned there, of course, about this being one of the biggest legal trials in recent history. Just to depart from Lucy Letby to talk about another huge, enormous, monumental trial in British history that you've been very involved in covering the case, of course, of the murder of James Bulger. And I wonder whether we could just touch on your work there, because you've done incredible work on that case over many years now, David.
Yes, I became involved in that case at a very early stage. So I'm from London, but I went up to Liverpool within a few weeks of the killing and saw the two boys for the first time at one of the magistrates' court hearings, the remand hearings. And I moved up there for a year, basically. So I had a commission to write a book. And so I've been very immersed in it. Of all the things I've ever written about, it's the one that comes back and never quite goes away. It's probably the most haunting case that I'll ever be involved in. And I also care very much about it and have my own views about the case. And my position has always been that it was a tragedy for three families. So I've always maintained that position because I see the perpetrators of the crime as being very young themselves and barely legally responsible for what they were doing.
Extraordinary now, looking back with hindsight, that they were named
Yeah, absolutely.
at that time.
Yes, it's a really interesting issue. And I think nowadays they probably wouldn't be.
And tried in an adult court as well, with judge and barristers in wigs, and they could barely see over the bars of where they were sitting, could they, to see what was happening? They were so tiny.
That's absolutely right. And in fact, they had to build a platform inside the dock to put them on chairs so they could see over the bar. There was a trial recently of a Wolverhampton case involving two small boys, not quite as small as Robert Thompson and John Venables. And that case made lots of other accommodations to their ages. They didn't have to sit in the dock. They sat with their families or supporters, and they were available to their lawyers. And none of the barristers or the judge wore any wigs and gowns. And it created a much more informal and appropriate atmosphere, although, still a Crown Court trial, as had been the case for Thompson and Venables.
Have they been named, though? Have they ever been named?
Those two, no, they haven't. The judge decided not to name them. Judges are increasingly making those decisions now, particularly because of the very young age of defendants.
David, thank you so much for coming on the podcast. Thank you for your insight, and we'll see what happens as this case continues and what the Court of Appeal have to say, even when the application is made, and if it ever does reach the doors of the CCRC, we'll hopefully get you back on. So thanks for coming on the podcast.
Yeah, thank you so much.
My pleasure. Thank you very much.
So such an interesting insight there from someone who used to consider possible miscarriages of justice. And it's just worth pointing out that I actually checked with the Court of Appeal yesterday, Caroline, and there's no new application been made yet by Mark MacDonald. But if he does lodge it, or if there is any new major developments, we will, of course, bring you all the details.
We definitely will, but that is it for now from the inquiry. We will be back in March for those closing statements, and then, of course, what we're expecting to happen is Lady Justice Thirlwall will spend the summer and maybe part of the autumn considering her recommendations. She's going to bring them back again, hopefully before the end of the year, and we'll find out what she has to say. But Liz, in the meantime, you and I have another really important case to cover. So next week, we'll be launching the new trial podcast on the tragic events that unfolded in Southport over the summer.
Yes, that's the trial of Axel Rudakabana, who's accused of murdering 6-year-old BB King, 7-year-old Elsie Dot Stankham, and 9-year-old Alice Da Silva Aguiar at a Taylor Swift-themed holiday club in Southport. And that's due to begin next Tuesday. And as usual, we'll be there at Liverpool Crown Court to keep you updated as it develops. He denies their murders and a series of other serious charges.
Don't forget, you can catch up with any of our previous episodes or listen to the other trials in our series, wherever you get your podcasts.
You can follow us at The Trial Pod on Instagram and on TikTok at Daily Mail Crime.
You can leave a comment on Spotify or send us a voice note on WhatsApp on 07796 657 512. Start your message with the word trial.
See you then.